हाणे 167 छा आहे सेक्शन जेको आहे असांजो द प्रोसीजर वेन इन्वेस्टिगेशन कैन नॉट बी कंप्लीटेड इन 24 hours. Whenever any person is arrested and detained in custody and it appears that investigation cannot be completed within the period of 24 hours fixed by section occurred, and there are the grounds for believing that the accusations or information is well found, the officer in charge of the police station or the police officer making the investigation, if he is not below the rank of sub-inspector, shall forthwith transmit to the nearest magistrate a copy of the entries in the diary herein after prescribed relating to the case, and shall at the same time forward the accused to such a magistrate. The magistrate to whom an accused person is forwarded under this section may, whether he has or has no jurisdiction to try the case, from time to time authorize the detentions of the accused in such a custody as such a magistrate thinks for term not exceeding 15 days in the whole. If he has not jurisdiction to try the case, send it for the trial and considers further detention unnecessary, and he may order the accused to be forwarded to magistrate having such a jurisdiction, provided that no magistrate of the third class and no magistrate of the second class not especially empowered in its behalf by the provincial government shall authorize detention in the custody of police. A magistrate authorizing under this section detention in the custody of the police shall record his reason so far doing. The magistrate giving such order shall forward a copy of his order with his reasons for making it to the session judge, notwithstanding anything contained in section 60 and 61 are herein contrary, where the accused forward under subsection 2 is a female. The magistrate shall not accept in the cases involving qatl or daketi are supported by reasons to be recorded in writing. Authorize the detentions of the accused in police custody, and the police officer making an investigation shall interrogate the accused referred to in subsection 1 in the presence of an officer of jail and a female officer. The officer in charge of the prison shall make appropriate arrangement for the admissions of the investigating police officer into the prison for the purpose of interrogating the accused. If for the purpose of investigation necessary that the accused referred to in subsection 1 be taken out of the prison, the officer in charge of the police station or the police officer making investigation not below the rank of sub-inspector shall apply to the magistrate in that behalf, and the magistrate may, for the reason to be recorded in writing, permit taking of accused out of the prison in the company of female police officer appointed by the magistrate, provided that accused shall not be kept out of the prison while in the custody of the police between the sunset and sunrises. 168 में रिपोर्ट ऑफ इन्वेस्टिगेशन बाय सबऑर्डिनेट पुलिस ऑफिसर इहो लॉ गेट में अची चुकियो आहे त इहो ज़रूरु जेको आहे अंडरलाइन कजो त कहिड़ो ऑफिसर सबऑर्डिनेट पुलिस ऑफिसर चए थो वेन एनी सबऑर्डिनेट पुलिस ऑफिसर हैज़ मेड एनी इन्वेस्टिगेशन अंडर दिस चैप्टर ही शैल रिपोर्ट द रिजल्ट ऑफ सच इन्वेस्टिगेशन टू द ऑफिसर इन चार्ज ऑफ पुलिस स्टेशन. ऐं 169 में रिलीज़ ऑफ अक्यूज़ वेन एविडेंस डिफिशिएंट चए थो उन अक्यूज़ खे रिलीज़ कयो वेंदो आहे जॾहिं छा हुजनि एविडेंस डिफिशिएंट. If upon an investigation under this chapter it appears to the officer in charge of police station or to the police officer making the investigation that there is not sufficient evidence or reasonable ground for suspicion to justify the forwarding of the accused to magistrate, such officer shall, if such a person is in custody, release him on his executing bond with or without sureties. Such officer may direct to appear if and when so required before magistrate power to take cognizance of the offences on a police report and to try the accused, send him for trial. Case to be sent to magistrate when evidence is sufficient. If upon an investigation under this chapter it appears to the officer in charge of police station that there is a sufficient evidence, a reasonable ground is aforesaid, such officer shall forward the accused under the custody to magistrate empowered to take a cognizance of the offences upon a police report and try the accused, send him for trial. If the offence is bailable and the accused is able to give the security, shall take a security from him for his appearances before such a magistrate on a day fixed, and for his attendance from day to day before such a magistrate, until otherwise directed. So when the officer in charge of police station forward an accused person to magistrate, takes the security for his appearances before such a magistrate under this section, he shall send to such a magistrate any weapons or other article which it may be necessary to produce before him, and shall require the complaint of any so many of the persons who appear to such officer to be acquainted with the circumstance of the case, as he may think necessary to execute a bond to appear before the magistrate as thereby directed, and prosecute or give evidence as the case may be in the matter of the charge against the accused. If the court of district magistrate or subdivisional magistrate is mentioned in the bond, such a court shall be held to include any court to which such a magistrate may refer the case for inquiry or trial, provided the reasonable notice of such a reference is given to such a complainant or person. The officer in whose presence the record is executed shall deliver a copy thereof to one of the person who executed and shall then send to the magistrate original with his report. 171 में complainant and witness is not to be required to accompany police officer. No complainant or witness is on his way to the court of the magistrate shall be required to accompany a police officer. Complainant and witness is not to be subject to restraint, shall be subject to unnecessary restraint. Inconveniences are required to give any security for his appearances other than his own bond. Recusant, complainant or witness may be forward in custody, provided that if any complainant or witness refuse to attend or to execute a bond as directed in section 170, the officer in charge of police station may forward him to in custody to the magistrate who may detain him in custody until they execute such a bond, until the hearing of the case is completed. Diary of proceeding in investigations. Every police officer making an investigation under this chapter shall day by day enter the proceeding in the investigation in a diary, setting a forth time at which the information reached him, the time at which he began and closed his investigation, the place or places visited by him, and a statement of the circumstances ascertained through his investigation. Any criminal court may send for the police diaries of a case under inquiry or trial in such a court, and may use such a diaries not as evidence in the case, but to aid it in such an inquiry or trial. Neither the accused nor his agent shall be entitled to call for such a diaries, nor shall they are entitled to see them merely because they are referred to by the court, but if they are used by the police officer who made them to refresh his memory, if the court uses them for the purpose of contracting such a police officer, the provisions of evidence sections of 72 sections or sections of the case may be shall apply. इनमें 173 report of the police officer. Every investigation असांजी 173 जेको आहे